get started. Welcome everybody. I'm Louis Lowe. I'm the founder of L2 Counsel. Thanks for joining our webinar about structuring IP and technology acquisitions. We have a rock star panelist in front of you, and I'd love my friends Adam, Natasha, and Patrick to quickly introduce themselves. Adam, why don't you kick us off?
Sure. My name's Adam Blinko. I'm at a legal intelligence company that also helps you find the right fit, particularly around the globe for your needs. I was a partner at Wilson Sonsini for many years, doing IPOs and M&A primarily. I was also general counsel of 2 public companies and 1 private company, all 3 that were fairly active, but both public companies were particularly active in buying public and private companies, divestitures, and I also teach mergers and acquisitions at law school. So,
thanks for joining, Adam. Natasha, tell us about yourself.
Great. Hi. Thank you, Louis. Name is Natasha Allen. I'm one of the founding partners of Allen & Hatcher LLP. Our firm specializes in corporate, startup, M&A, venture financing. My background is historically in tax, but I have done numerous M&A transactions throughout my legal career, and I'm just excited to be here.
Natasha, thank you so much. Patrick, I'm so glad you could make this. I'm going to spend a minute introducing you. Patrick Stroth is the founder of Rubicon M&A Insurance, and Patrick has been really rocking Silicon Valley, serving a really deep market has been in great need of a solution of an insurance product. And Patrick, I'm so glad that you could join us. Your productions on M&A have been inspiring for me, and I'm really glad that you could join.
Absolute thrill to be here. Thank you very much. My name is Patrick Stroth, as Lou was kind enough to say. President of Rubicon M&A Insurance Services. We're an insurance broker that is a boutique shop that works almost exclusively with insuring M&A transactions. And the objective here is to enable owners, founders, and their investors to exit, get a clean exit when they sell their companies, where we remove the real problem in the conflicts with M&A, and we can get into that a little bit. And it's an absolute pleasure to be here.
Thank you so much. And for everybody who's joining, Adam, Natasha, and Patrick and I have worked together on technology M&A transactions. And I just wanted to, before we kick off, put ourselves in the current context of the economy reopening and hopefully a burst of positive energy going through the technology ecosystem. But I think we all foresee that as the year progresses, that some technology companies are going to go cash out. And we as M&A professionals and entrepreneurs are going to be faced with either the one side of that equation being on the buy side or the sell side of trying to resuscitate that technology into a new platform, and either trying to sell it if you go cash out, or trying to acquire IP assets really smartly if you're on the buy side. And I had the pleasure of working on a number of these transactions with Adam 10 years ago as we were emerging from the last recession, and it really gave me the idea to do this webinar. And so thanks, Adam, for being my inspiration. Today, the agenda is in front of you, and we're going to try and quickly explain the various transaction structures that we see. We're going to talk about some due diligence issues. We're going to talk about the key reps, warranties, and indemnities that are relevant for intellectual property and technology acquisitions. And then finally, we're going to hit some hypos, and frankly, I hope we spend most of our time talking through the hypos, because that's always the most fun and engaging. I invite everybody to interrupt us, disagree with us, call us names. It'll make it more fun. So quickly, transaction structure. Adam, Natasha, Patrick, as you think of how to acquire an IP asset, and I always think of an IP asset as the code or the technology, and oftentimes the people that know how to exploit that technology. How do you think of the initial structure if you're on the buy side. Are you looking to do a stock purchase, a merger, or would you not rather acquire the asset and leave behind any liabilities? And Adam, I'll start with you.
Sure, but I'm gonna kick it over to Natasha because generally it's tax driven, right? You think about the tax driven, and then you think about the consideration being paid. And so the question is, does the buyer want to use cash or stock? And what kind of currency are they using for the acquisition itself? But a lot of times the structure is driven by the tax considerations. And so, you know, are you buying assets out of bankruptcy? Are you buying a division? Is it a divisional sale? Is it an operating division? Do you have to do carve out financials? Or is it purely a quote unquote technology acquisition? Are you buying the intellectual property? And intellectually, I like to separate the two because they have different ramifications that we'll get into down the road. But Natasha, would love to get your perspective from a tax expert's view, because I think those are some of the key structuring drivers on that front.
Yeah, so tax was a historical career of mine, but definitely agree that tax usually drives these transactions in terms of which is most beneficial. I think practically speaking, it depends on what the buyer actually wants. If the buyer can be very bespoke in terms of what assets they want to acquire, it makes sense to just go in and take what you need to take, to the extent it can be bifurcated from the entity or the corporation that it's encompassed in. Stock purchase is a great situation if you just want to take whole hog everything. In terms of tax, you can, depending on what assets you're acquiring, you can get depreciation. Under stock purchases, it depends on if the company has NOLs that can be transferred, so non-operating losses that can be used by the buyer. But it is a key consideration, I think, would be tax, but also if it's a situation where you can actually figure out what assets you actually specifically need or want. Sometimes it's better to go for the asset sale. As we all know, on stock purchase transactions, you're not sure what skeletons are in the closet. So in terms of acquiring a company whole hog, you don't know exactly what you're getting into.
Thanks, Natasha. And from the buy side, I always look at these things as you know, especially when there's a distressed situation, as only wanting to acquire the asset and leave behind the liabilities. And obviously, if I'm the seller, I want to get rid of my whole entity and whatever liabilities there are, and I don't want to be stuck with them. So that's kind of the critical consideration is, do you have the leverage if you're the seller to force the buyer to acquire you in a stock purchase or a merger? Merger is typically easier because you can cram down dissenting holders and minority holders, and you don't need the signature of every single stockholder or an option holder to affect the transaction. So a merger is the easiest and best deal if you're the seller, typically, and an asset deal is the best deal that you can have if you're the buyer, strictly from an IP perspective. Obviously, cash, stock, tax considerations abound, but today I wanted to talk about, you know, just the IP issues. And as I was noting at the outset, I find that technology really can't operate without the people. And so we often have this question or conundrum of how do we exploit the IP and how do we get the people with it? And so sometimes the IP needs to stay with the selling entity. Maybe they're going to retain the IP and just give a license. Maybe they're going to sell sell the IP and retain a license. And then, you know, transition services, is that going to be required from the buyer to the seller in order for the seller to be able to exploit the IP for some period of time until it can acquire its own talent? So that was what I wanted to cover on structure.
Just to put a bow around, I think that's right. You know, the people aspect and the engineers that you might need, or the sales team, can't be underestimated and can tip the balance in one direction. I think the other thing is just ensuring that you get everything. Sometimes an asset purchase from a buyer standpoint can be very nerve-wracking when you want to integrate and operate that business going forward, because you're exceptionally concerned that something fell off the table and you don't have something you need to operate the business.
Yeah, one of the other things I want to throw in here, just from a risk perspective, is in addition to tax being a driver, there's also the concern on a buyer on just what liabilities are they picking up. And traditionally what happens in these transactions is, to reduce the amount of risk, the buyer is trying to push as much risk back to the seller as possible through the purchase and sale agreement. The seller is going to react, and that's where we have some conflict, because the seller, you know, they'll in their opinion bare their soul. They'll open up their books. They'll tell you everything they know, and the buyer still says, "That's nice, but you know, I'm betting on your memory being perfect, so we're going to push even more liability to you." And the problem for the seller is, well, what if there's something out of the blue that happens? So there's risk involved that's, you know, out there. What's been nice has been the development from the insurance industry, where they are able to take some of that risk off of the table for both the buyer and the seller, and assume it. We'll get into that a little bit more with reps and warranties, but that's another element there that we remove conflict is helping with reducing risk for both sides.
Thanks,
Another
Patrick.
situation, or another factor, sorry, Louis, that I just want to get back into is with regards to assignment of contracts and whether a change of control or assignment has to happen. And there's different ways to treat a contract in a merger, depending on whether it's forward, reverse, stock sale, and just interpretations of those assignment and change of control provisions can come into play and be very, very tricky and sometimes.
That is a really great point, Natasha. So I'm going to turn this back around on you. When you're representing a buyer and a seller has hundreds of contracts or maybe just POs, you know, how do you really analyze that risk, you know, efficiently and quickly as to whether or not a contract will be assignable just in an asset acquisition or a stock purchase or in a merger, or whether some sort of consent is required that would allow the licensor to hit you up as the buyer for some, you know, unknown amount of new license fees post closing?
Exactly. So it really depends on the type of transaction you're going to be engaged in. So I would start at that point. Is it going to be forward, merger, stock purchase, reverse merger, triangular merger? If there is no assignment language, typically, you know, the courts say that it's assignable. If there is some assignment language, you have to be careful in terms of assessing whether it's a stock purchase. Usually a change of control occurs in a stock purchase, but you can get around it if it's not all or substantially all. But to get back to your question in terms of how to assess it, it's very difficult. You just literally have to read the agreements. I've been in the position where we've gone through agreements, a ton of agreements, to try to make sure that you're covered off on this position. Especially in the situation with a reverse triangular merger, where there's a bit of debate in terms of, you know, whether there's an assignment, whether there is an assignment. The courts are a little, you know, on the fence in terms of what situations result in an assignment or an assignable contract. And so it's very fact specific and fact driven. But you could do things such as, you know, having thresholds, so certain contracts that are worth certain value, to focus mainly on those agreements, which I've also done in the past when you are in a situation when you have thousands of contracts and just the time doesn't allow for it. That's one way to do it. In terms of what type of technology is being licensed by that particular agreement, that could also be some type of threshold that you could use in order to kind of bifurcate the agreements and figure out which ones you'll look at more in depth.
It's a great question, and it's a great answer, and it segues to our next slide on diligence. And, you know, how do you efficiently and rapidly assess that risk? And I think you nailed it, Natasha, in terms of, you know, first it's a question of structure and looking for the language in the contracts. And I think increasingly it's becoming best practice to work with a technology-enabled vendor. Kira Networks is one that springs to mind, but there are many other really good ones that can instantly, using artificial intelligence, analyze a whole library of contracts, looking for search strings that you will have programmed into the engine to find that assignment language quickly. Now, I'm still not confident enough that the engines are advanced enough to rely on them without a human reading those contracts. But I do find that using these artificial intelligence engines really can increase your efficiency and accuracy just by running the contracts through the engine. Any other technology tools that you use, Natasha? And for those that don't know, Natasha spent some years at Atrium, one of the leading technology legal tech companies in San Francisco, and I'm always looking for new hacks to get through transactions smarter, faster, cheaper. What do you think is best in class, Natasha, in terms of how to do it?
So I think this was something that we struggled with a lot at Atrium, trying to find the right technology in an M&A transaction. We found that some of the technology that's being used in litigation could be dual purposed for M&A transactions, like you had said, Louis, in terms of just identifying key language, key terms that can help you distinguish or, get between agreements or figure out which agreements are relevant. But particularly at Atrium, we had not figured out the situation or hadn't figured out the problem yet. It takes a lot of, as you know, with AI, it takes a lot of agreements in order for the machinery to understand and learn. And we were in the process of getting through what would make sense. Some of the technology that we were using or establishing had to do more with how do you organize transactions or M&A transactions. So ensuring that there was a streamlined process for all parties to follow. So more of use of a platform to kind of organize all the different facets that go or happen within an M&A transaction. So that was something that was easier and more attainable to try to achieve within the short time frame that we were able to do so at Atrium.
Yeah, I'm seeing that the really big and sophisticated technology buyers are using the same, specialized advisors on M&A transactions just for the IP side. So while you might see one corporate law firm handling kind of the quarterback or the coach of the team, you're seeing firms bring in a special IP team just to that really understands the buyer's IP and how the seller's IP could fold into it or not, to come in and do that. Obviously, you're also seeing the insurance providers like Patrick and his firm coming in with their own counsel to do a due diligence of the due diligence. And so I'm finding that as seller counsel and as buyer counsel, I'm managing two processes, one with the counterparty in the transaction and then one with the insurance provider, and making sure that everybody stays in sync. Adam, as a former general counsel as well as a law firm partner at one of the best firms in the world, what are the considerations that you had in moving quickly on an IP transaction? I find that oftentimes somebody brings a distressed asset, and in order to acquire it, you've got to move quickly. And so if you're not able to move quickly, you really can't do the deal. But if you do something quickly, what are you going to be stuck with? What were the kinds of things that you thought about as the general counsel of a global tech company when doing these acquisitions?
I think we hit on some of them, and that's a pretty broad question, but big picture, I do think the structure matters. Kind of, if you're buying the whole company and it's a public company that's been in business for a certain amount of time, and you're not excessively worried about upstream licenses that might affect your own patent portfolio. There are some companies that are particularly concerned about that, and that's where those specialized advisors in an M&A transaction are critical, because a lot of the AI checks for things like consents, but the upstream license impact can be crafted in so many different ways. I'm not confident they pick that up. But that will give you some sense, and when you're working with the insurance companies and their teams, some sense of the risk profile. Depending on the scale of revenues that have been extracted from this technology, what is the risk that a third party is going to come out and sue? So part of it is the relative size of the two companies. So let's say you have a really large company, high profile, tends to be a target, buying a smaller private company, that the temperature and the concern level tends to go up. And I suspect, Patrick, you've seen this a lot. If it's a large public company buying a mid-sized public company, very different. If you're buying the technology itself out of bankruptcy and you're doing it as an asset acquisition, you can kind of avoid some of the issues other than the infringement. And, depending on how high profile it's announced, you get the patent trolls coming out and coming after you for that transaction. So there are a lot of different variables that impact the risk profile, but the rule of thumb I tend to look at is how long has it been in the stream of commerce, the technology itself, and how much revenue has been generated from that. That will help you gauge it a little better than at least as a starting point, as a proxy for that.
Thanks, Adam. And what's your view on some of these technology vendors that offer their services to check out the IP? And I'm thinking about the black duck scan if it's software, and if it's hardware. I'm sure there's an equivalent. What's your thought on timing, cost? When do you use them? When do you not? How much do you rely on them?
Right. I think if you're worried about the code, somehow the code being tainted, and you're uncomfortable with the procedures and protocols that the target company has in place, or if you're the target company and you have weaknesses in, let's say, regularly doing a black duck scan of your code to make sure that, even if the company's policies say don't use open source without clearing it through a panel, that it hasn't found its way in and tainting, and this is one of the hypos, kind of jumping ahead, in tainting some of the crown jewels of the target company, because that can be a problem, and it's frankly stopped some deals in their tracks. So I actually think companies like Black Duck, if you're very sensitive to open source issues, are instrumental to helping actually understand the risk and potentially quarantine it. And if you potentially have to remove it or recode to get rid of that offending issue, and depending on which open source it is, can have different levels of toxicity. So I find Black Duck and companies like them in the open source side critical. The technology, it depends on are you buying the technology, or are you buying a hardware product? Is it a cloud services company where the value is in the user base and the activity on the platform? They're less concerned about the code. The issue is not actually licensing the code out to somebody else that might embed it in a product, but it's really the platform itself. And that pressure goes down if the value in the technology is the user base, the traction, et cetera. It's not so much actually the copyright in the software code.
Gotcha. And I'm just into the Q&A, and Drew Skarupa has asked some really smart questions about Black Duck and similar vendors, and what does it cost, and is it cost efficient? So any enterprise SaaS company, and we live in an enterprise SaaS world in Silicon Valley right now, is going to have code. Engineers are famous for having to push out new versions of product quickly, and oftentimes integrating open source into their code. The downside of doing that is that the code then could trigger a loss of intellectual property protection, or the triggering of a fee or some other obligation. And so it is important to both anticipate that your engineers have done that if you're writing code, and to find a way to ferret it out on a regular basis. And certainly before you launch a sales process, just like you would try and have audited financial statements, or at least quality of earnings, you would want to do the same thing with your code by having a black duck scan done. And much like you would sell your house with all of the inspections done and provided to the seller in an auction process in advance, to the extent that you can anticipate a sale, you'd want to do that. People often ask me, what does it cost? And it's kind of an unfair question, because every piece of software is different. But I would say that a single software package, Black Duck scan, typically in my experience, and I'm not working for Black Duck, will cost between 20 and 30 grand, and can take anywhere from 2 to 4 weeks. I'm sure that they can go faster if you pay them more money and deploy more resources. But Drew, it's a great question that you should anticipate it, and the cost is probably somewhere in a quantum of 20 to 40K, and the timing is probably in a quantum of 2 to 4 weeks. Now, they typically identify some open source in your code, and then you've got to also anticipate the time to recode or rewrite the open source code into unique code that doesn't rely on open source. So in other words, to cure the defects that are found. And that's another, process that, can move very quickly if people are really focused and know what they're doing. Can be solved in a day, but oftentimes not. And you'll need to plan for some more time and then assess whether or not revenues recognized to date are in jeopardy and what would be the consequences to revenue. So really great question, Drew, and timely, and thanks for that.
Let me jump in on one thing here, Lou. Just in a historical perspective, one of the reasons why rep and warranty insurance ensuring M&A transactions had been around but not really moving forward was one of the most common exclusions was intellectual property. For rep and warranty has been around since 2000, but they until maybe just after 2010, they would not insure IP reps. So for Silicon Valley, anything in technology, what's the use of the product? It's like, so what has happened though is because of these third parties, greater due diligence, more resources being brought to bear to vet out the problems, and there's a dilemma because, well, we don't want to turn up all these other defects that now we have to deal with, but in doing so, it enables the risk could then be shifted out permanently because if the fixes are there and something else were to come up, now it's a coverable item. And so it's been a routine thing. And it's kept, IP reps represent a sizable portion of the claims for rep and warranty insurance. However, they haven't been as large because a lot of these things have been preempted by this diligence now. And the improvement in diligence has really helped. And it was a great point you made, Lou, is that the insurance industry isn't here to diligence a deal. We're just grading the diligence that was performed by the buyer. And the better that is, the lower the rate, the better the coverage.
That's a really good point that we're going to come back to is how do you see yourself in your diligence exercise? And I really like the way you put that. And it's a nice segue to where we were going next as the due diligence really is designed to verify that the reps, warranties, and indemnities work. And before we dig into this topic, I just kind of want to set the stage as to how we intervene. And as M&A professionals, we get called into a situation and it could be very different. So if you're a big tech buyer, we won't name any names, but we know who they are, running a Rolls-Royce process and paying full value for an asset, they're going to insist on a clean sufficiency of IP rep. They're going to insist on getting reps that are totally unqualified by knowledge or materiality. And they often consider intellectual property reps as fundamental, therefore going above and beyond whatever escrow or insurance cap that applies to basic reps and warranties. And that's the sort of the theme of the deal. If you're in a situation where it's big tech buying an asset where they have the leverage to impose their will, but you're often in another circumstance where you've got a really hot private equity backed asset where the private equity firm is trying to get out completely and cleanly in a competitive process, and where they're not going to want to give strong IP reps. They're going to qualify the heck out of them with knowledge, materiality. They're not going to want to give any kind of sufficiency rep, and they're going to want all of all of this to be backed by rep and warranty insurance. And sometimes that's possible to be in a situation where you can bring in insurance, but oftentimes you're not. It's a distress situation. There aren't funds available for insurance. The seller is only going to do the deal if they can get out quickly and cleanly. And so if you're the buyer, you're kind of assessing, well, geez, it looks like a good hamburger, but I don't know if the bun's rotten. Adam, as a member of a senior management team of a global tech company, I know you've been in all of these situations. How do you assess the risk of moving forward, and how do you explain this to your CEO and CFO who probably want to boost EPS and don't have time to talk about legal technicalities?
Yeah, well, it's interesting. In large, complicated deals, you tend to get like a page or two to present to the board about the legal issues. So you're spot on. I actually do think rep and warranty insurance is critical to get wherever you can, and it because it transcends the reps and warranties or the indemnity themselves. And what I mean by that is there's a practical tension that was touched on earlier in this presentation, and this worried about what's going to come out of the closet with infringement down the road creates such stress and strain on the overall deal that the mere process of having some level of insurance, even if it's only the first tier, even if there's risk, some risk allocation above and beyond that, actually changes the dynamic a bit, and you can focus more on integration of the businesses. Because from an inside standpoint, whether you're on the buy side or the sell side, you're actually not just thinking about closing the deal, you're thinking about operating and how you're going to integrate and monetize the asset after the acquisition. And so rep and warranty insurance can be fundamental to actually change some of the dynamics and reduce the level of tug of war of risk allocation. It brings in another validation of reasonable risk. It helps the board, and this is your core question, be comfortable that this is a measured, thoughtful risk to take. Business people are used to taking risks, and they just want it to be measured. And what causes them consternation on the IP side is it's this kind of morass of intellectual property rights, and what's the difference between technology and IP, and what does infringement mean, and how can we get sued for infringement if we have patents? Those can be very esoteric points and not particularly relevant to the board. If they can get a measure of assurance on the buy side or the sell side that whatever risk tolerance they're taking, it's commensurate with the benefit of the bargain. And I think that's really what the goal is at the business core, is to marry those two, that the risk is appropriate for the potential upside. And that's how I look at it. And I talk to the board in business terms, not just, so I talk about operating the asset, talk about the risk, help them understand it, because things can come out of the woodwork. And but you have to put it in context.
I would also say that the development of the product over the last couple of years, Lou mentioned that if you are a buyer and you have a Rolls-Royce diligence process, the market may have required real strict high standards for diligence in order to insure something. Otherwise, they start loading in a lot of exclusions or limit the coverage. That's lightened up because there's been a lot more competition in the insurance industry right now. There are over 20 insurers, and probably 10 of them are the real legit players. There are 10 others that have now come in, and they're putting pressure on these companies to provide broader coverage based on maybe a little less diligence. There still has to be the good, honest effort there, but it's not as stringent. Thinking about it other than IP diligence, but if you think about financial diligence, rep and warranty policies would not apply on any company where the target company did not have audited financials. It was an absolute deal killer. You were ineligible. That's no longer the case. There are many markets now that are willing to competitively price and cover financial reps based on third-party reports, not audited reports. Same can be done with IP. If there is, a good, honest effort of diligence there, and we're not insuring $200-300 million, a much smaller insurance policy, then there is availability out there. And the issue with IP is a fundamental rep. There are policies now that will go ahead and flex to whatever the purchase and sale agreement says. And so if IP is going to be a fundamental rep, the policy will go for that entire term up to the policy limit. We have seen tiny deals, $13-14 million transactions being insured to $13-14 million in coverage. I mean, you can't even get that kind of coverage on a car, driving off the lot. Okay.
Patrick, I was going to give you that question as a softball, but you've already answered it, and it's why you're on this call and on this webinar. And it used to be that 5-10 years ago, when you thought about insuring a deal, you had to have a minimum premium of $3-4 million, which meant that the size of the deal needed to be well north of $100 million for it to even begin to make sense. And Patrick and his firm Rubicon really moved into a space in the market below that. I think they play well above it as well, but you know, the middle market of tech M&A, which is, you know, sub $50 million deals, and Patrick and his firm have really stepped into the void to provide a solution where there previously wasn't. So thank you, Patrick, for joining this webinar and calling that out and sharing with us how you assess that. My good friend and colleague Roger Royce has asked an interesting question that I think is relevant for you as well, Patrick, and that's who pays for the insurance, buyer or seller? I've seen both, but I'd love to hear from your perspective. You know, when does it make sense to do a buy side policy versus a sell side policy, and the premium and the difference in premium?
Yeah, it's another great thinker in M&A just said, whoever has leverage tends to use it. Is whoever has leverage in the deal. Okay, we have cases where the buyer will pay for it because we have a very highly desirable seller and the buyer wants to preempt the process. We've had a situation where sellers, many times you've got a large buyer, but the seller will insist on paying for it because you'll have within the seller one or two major shareholders and a lot of minority shareholders, and they don't want to be the deep pockets, the major shareholders, so they want to get the policy and they're insisting on it. They drive the process, and oftentimes we will see both sides go ahead and just split it. And I mean, when we talk about the prices, I like to think of it, I compare rep and warranty. Now Moore's law has now hit the insurance industry too, because as time has gone on, the capability of the policies has grown and the costs have shrunk. We've seen these policies now on transactions for, I mean, literally a $10 million acquisition, and the premium all costs in is under $200,000. And it's split in half if you got both buyers and sellers paying for it. So it's in an area where I think the lower middle market really isn't being served well because they're being overlooked because of the larger deals that are out there. And there are thousands of these smaller, you know, entrepreneurs out there that could really get some help with these types of products, both, you know, with the diligence and all this, you know, the guidance and the counsel, and then also just eliminating the risk. And as a I'm very proud of the industry moving into this direction. And that's why we want to spearhead it.
Well, you've really filled a huge need, Patrick, and it's really great to have you available to jump into deals and provide that solution. So you know, two more questions from Roger, and then my good friend Rick Arnold, the general counsel of Altos Ventures. The first one is, you know, in the negotiation of the reps, you know, if we're outsourcing the risk to a third party insurance provider, you know, why does anybody fight about the reps and warranties anymore? Wouldn't the seller get more purchase price if they gave, you know, rock solid reps that are backed up? And do you see, Natasha, as an M&A lawyer, kind of a fusion of interest between buyer and seller as soon as there's insurance to have, in fact, unqualified, you know, very strong IP reps? Or do you find that, you know, you still have sellers pushing back and trying to have weaker reps, whether or not there's insurance or not?
I think insurance obviously provides some comfort in terms of if there was a mistake made. But I do think, depending on the type of IP you're talking about and what rep you're relating to, there has to be some type of understanding and some assurance to the buyer that the seller can rep and warrant to certain IP. So in the instance of, say, patents, patents are very difficult to rep that there's non-infringement. So that might be a situation where you may have a knowledge qualifier, just given that, you know, if you have a patent application, it takes 18 months for it to be published. You'd have to scorch the earth in order to find out if there is another patent application. So that's a situation where you can have good understanding that there should be a knowledge qualifier. With regards to trade secrets and copyrights, shouldn't have any knowledge qualifiers. Those are things that the seller should be able to rep and warrant to, that they understand that they own the title and have not had any infringements with trade secrets. So I do think that insurance does provide some comfort, but there are some reps and warrants that there should and should not be knowledge qualifiers attached to.
There's actually,
Patrick, are you, and one of the questions that Roger's followed up with is do you, as the insurer, somehow participate in a negotiation between the buyer and the seller of those reps? That's not my experience. My experience is buyers and sellers negotiate the reps, and then the insurer comes in and backstops that with a policy. I do want to note, Roger, that every insurance policy that I've ever seen does not cover known risks. So things that are listed on the disclosure schedules, litigation that people know about, unless there's a special policy written on it, is generally excluded from the coverage. And Patrick, interrupt me or correct me if I've got this wrong.
Okay.
And so, the buyer and the seller needs to negotiate the contract, get it to some sort of close to a final state of reps and warranties, and then hand it over to the insurer. And at that point, I find that there's usually a 2 to 3 week process for them to get going, look at the agreements, check that a diligence investigation's been done or not, and then price it and deliver a policy. And I'm finding that the work required to do that, oftentimes it needs a $50,000 deposit to get the insurer to pick up her pen and get to work. So that's what I'm seeing. And Patrick, correct me if I'm wrong on that.
Although the early days, I would get that question a lot as well. How can we do you have standard wording for certain reps so that we can take something that's not insurable and make it insurable? That's not what they're just not going to do that. They're leaving it to the buyer and the seller. And there is evidence now, as rep and warranty is being used more often out there, that we see some collaboration between the buyers and the sellers, where the wording is in the middle for the both of them that feel comfortable, provided the insurance company is comfortable with it and willing to insure it. Then both sides, the negotiation stops. So knowledge qualifiers, materiality scrapes, all those. The insurance policy itself is going to mirror the language that is in the agreement. The interesting thing is if there are issues like consequential damages, if consequential damages are silent in an agreement, there will be no exclusion for consequential damages in a policy. If there are consequential damages, there are some insurers that don't like that. Some do, some are willing to do it. So there are elements of that out there, but we see that once a rep is insurable or qualifies for the insurance, all the discussions stop. They move on to the next thing, which is the magic of rep and warranties. We remove a lot of the contentious issues from this, not only on the scope of the reps, how much indemnity should be there, and that's just how big or small a policy you want. That it's solved. I get a lot of concern from parties on survival periods and policy. It's the same as beautiful because it's the same price, and we'll have all the reps, considered fundamental if you want, if that's necessary to the survival periods. Very, very flexible. So when the negotiations end, once something is insurable, and there's evidence, as we've seen a lot of savvy attorneys out there knowing that if we word it this way, both sides, this is going to qualify for coverage. We've got the diligence behind it. They move on.
Well said. I think you've accurately stated my experience, Patrick, but I do think it's fair to build into your process, if you're going to be purchasing a policy, that there is a policy document that you can negotiate with your carrier, and people like Patrick, who are brokers, come in and help shepherd the process so that it's smooth and priced as efficiently as possible. But there is another work stream to build into your M&A process when there is insurance, and there are some tricks of the trade to make sure that you optimize the terms of the policy. And I think we'd go beyond the scope of this webinar if we went too deep into that rabbit hole, but it's a fair question. Patrick, can you give some examples of when M&A insurance has paid out to a buyer and to a seller on breaches of IP reps, or without jeopardizing confidentiality or can you speak to that question at all?
I can speak to a scenario I'm aware of. I'm knock on wood, I have yet to have a claim report even reported yet. So I'm very, very fortunate that way. We'll keep it like that. We have had situations where a third party, where a buyer acquires intellectual property, and buyer, not fairly high profile buyer, goes and starts using that IP, and then out of the blue, a third party comes in and brings a breach, because now we've got much deeper pockets out there. And so we've seen that type of issue quite a bit. There's also concerns where we've got former estranged isn't the word, but we have disgruntled employees or former employees that may be putting on allegations of their IP that was taken once the transactions happened. That's been the most common that we read about right now.
Patrick, another question. Insurance always steals the show on these webinars. Sorry to keep hitting you, Patrick, but the participants are really appreciating your perspective and your presence. What do we typically, how do we typically think of pricing M&A insurance generally? And then specifically, if you're only insuring the IP, is there kind of a rule of thumb on how to think about insuring just the IP reps? I've not done a deal where we only insured the IP reps. I have done deals where we've purchased a separate policy for the IP because we were specifically concerned about an existential issue rather than an identified issue. Once you have an identified issue, that's hard to insure.
Yeah.
But existential issues are things that you can insure, and so I've seen that. But are there any rules of thumb that we could talk about in today's insurance market?
Sure. Well, the rule of thumb right now is don't worry about transaction size. Transaction size doesn't have any bearing on the price of the policy. Okay. It's just how much insurance you're going to buy. So the more insurance, the higher the price. So you could have a $50 million deal. If they only want $5 million in coverage, then you're going to be at the lower, the minimum pricing threshold. If you want 10 million, 15 million, it's still a $50 million transaction, but the policy goes up. So it is usually a percentage of the limit. And the rate has come from, in 2010, a premium was 10% of the limit. So if you wanted a $1 million or a $10 million limit policy, it was $1 million in premium. Okay. Add to that, there's an underwriting fee between $25,000 to $50,000. Add to that taxes for whatever state the buyer's domiciled in. Today, that percentage, instead of 10% of the limit, is now closer to 2% of the limit. So now that same $10 million policy is going to be, a couple $100,000. Okay, probably between $200,000 and $225,000 for a $10 million limit policy. We are seeing policies. I'm doing a lot more of these $5 million deals that are $145,000 to $160,000 in premium. Add $30,000 underwriting fee, and you're $175,000 to $190,000 in cost. And so the pricing has really fallen. Should we go into an IP only policy? A couple of carriers will do IP only, and you're probably going to save about 15% on that 150. The absolute floor for a legitimate carrier is $100,000 to $110,000 is the absolute lowest. If you've got a rep and warranty policy that's under six figures, I am not very confident that carrier, that insurer, will be around if a claim happens a year or two later. So there's got to be there's that floor that's out there. But no, I've had a situation. Full disclosure, we did not close the deal. For some reason, they didn't go forward. But we had some programmers that sold their programs to a gaming company, a very large gaming company, and they had a big IP rep out there. Before they had come to me, they went and closed the deal. They later came back and said, "Can we do it's after the fact, but can we get a policy for the IP reps?" Which we were able to do, and it was at a lower threshold than a regular rep and warranty policy, about 15% off. Okay, they ended up you know, once the deal was closed, after they were very scared for about a month or two, as time went on and nothing happened, they got braver and decided not to spend the money. Yeah, but it is definitely out there.
Thank you so much. I'm cognizant of time left, and we've got 6 minutes before the end of the hour, and I wanted to make sure that we hit some of these red flag issues. And Natasha, Adam, Patrick, free for all here. What are the kind of red flags that our audience should be looking out for in technology and intellectual property acquisitions? Natasha, do you want to start?
Sure. I'd say for joint ownership, you just want to make sure what you're owning jointly. If it's patents, obviously you can exploit the patents without having to account to the other patent owner, except for if you're in a situation where you have joint ownership for copyright. Even though you can exploit it wholeheartedly on your own, you do still have to account for royalties for the other copyright owners. So just to be cognizant and aware of that in terms of when you see joint ownership. Getting an understanding of how it's been exploited, who are the parties that jointly own that particular IP, and whether there's been any accounting for royalties or fees that would have come in.
That was a tour de force. Well said. I'm going to go hit the next one and open source. I think we've hit this pretty carefully, so I'm going to skip this slide in lieu of the time. What are you looking for in the licenses and the other diligence agreements, and how do you do it quickly and efficiently? I think you hit on some of this already earlier in the call, Natasha. Fixing some revenue materiality thresholds at the outset with your client or your internal client. Anything to add here that we should cover on this slide? And Adam, feel free to jump in, as I know you have so much experience just from a management perspective assessing the risk on these kinds of transactions.
Natasha, did you have a comment? Because
the materiality was the main comment. Go ahead.
There are probably two things, and I try to be real practical about these. One, as a practical tip, be wary of contracts that say that so if you've got an inbound license, the target has an inbound license that says that the target can't unreasonably withhold its consent to the assignment, because you can always find a reason. And that is, as a practical matter, equivalent to a veto right. So you have to think about getting held up for additional money in the context of that. Don't get too comfortable about language like that, because you're not going to be able to go to court and force somebody to give their consent. They can always find some reason that would withstand that scrutiny. So that is a hollow shell. The other thing, I want to tie together some of the comments earlier about inbound licenses, and this got touched out in the call indirectly, and because a few people talked about a Rolls-Royce of transactions. Well, when Rolls-Royce was sold to Volkswagen, they didn't really focus in on the fact that the brand Rolls-Royce was licensed from the airline engine company, was not owned by the automobile company. So when VW acquired the Rolls-Royce brand, they basically got the old factory, they got a right to use the grille and the image on top of the grille, but they did not actually get the Rolls-Royce brand. And it was a big mess. And BMW ultimately acquired the licensing rights to the Rolls-Royce brand for a fraction of the acquisition price of Rolls-Royce cars. So this is just a little, again, a practical view of pause and think about what you're buying. The risk taken isn't always commensurate with the purchase price. You can be doing a distressed asset sale, and lo and behold, you embed that, the buyer embeds that into its core technology, and now all of a sudden it's got massive exposure, even though the purchase price was a fire sale, okay? So you have to think about how you're gonna use it. Have to be mindful of the time to market issues and the pressure on these technology deals because of the issues inherently in the sector. Everybody wants to get things done yesterday. But you have to know what you're buying and calculate the risk accordingly, because there are hidden landmines in the IP world that can come back to bite you. And so it could be an inbound license. It could be a license without sub-licensing rights. That's part of the core product. And you need to think about the distribution model. So you really, from a business perspective, you also need to think about how you're going to use the technology as a practical matter going forward? Are you going to end up sub-licensing it, et cetera? And you need to make sure you have all those rights so that you're not in a position of infringing somebody's IP knowingly or, or inadvertently stepping on somebody's toes.
One other thing is tangential to IP, but it's one thing that underwriters are really focusing on more, particularly if you're a technology company, you've got subscription recurring revenue and things like that, and you have customer information. The security you have on your data, not only your IP, but on your customer data is absolutely critical. And rep and warranty will look, if you do not have a cyber liability policy to be your first line of defense, the rep and warranty policy is reluctant to be down lower for cyber related issues. And I would say cyber is the most no-brainer purchase any tech company needs to make. It's for less than 20 grand, you have a $10 million policy limit with maybe a $25,000 deductible. I mean, it's nothing. And rep and warranty likes to sit right on top of that for cyber. So it is another part of the diligence process, but it's now intertwined with IP. Is there's going to be a question about cyber liability. And the easiest fix on that is obviously have your security, you're going to have it, but get an insurance policy for that. And it's cheap and it's great value.
Patrick, thank you so much. And as we wrap up our first hour, I think we could go maybe 10 more minutes. And for those who need to drop, feel free to follow up with us. We will be sending around an email with these slides with everyone's contact details, as well as a recording for those that missed portions of the presentation. But I wanted to spend a word on, assessing the process. And Adam, I remember you had a stint as an investment banker, and we probably should have had an investment banker on this call, but if you wouldn't mind jumping into that role for this segment. When you're looking to sell, do you need a banker? How do you go and find a buyer? And I would just like to start by saying that, increasingly, even in the lower middle market, there are advisors that are extremely specialized in your area of the market. And I really recommend working with bankers that are focused on a product segment or an area, because increasingly they're really differentiated, and to know who is a potential buyer, you really need somebody who's focused on knowing who needs what IP. And I just wanted to do a shout out for Elver Kozovic, who just opened a tech-focused IP boutique called Tech and IP Capital. And he's somebody who I've always talked to when I had a client who was looking to either buy a specific piece of IP that they didn't know where it was, or a seller who was trying to monetize a specific piece of IP and find out how to value it and find a buyer. Adam, any thoughts on that topic?
I think you've hit it. I think it depends. It's a mix of bankers who know the sector, corporate development people that are looking to buy or partner. So if it's the smaller company running a corporate development group, thinking about what acquisitions you want to do and why. And then there are highly specialized professionals, let's say patent brokers, right? I mean, that is, I've done some large patent acquisition transactions, just the patents, nothing else, no operating business, no software, no copyright, just the patent portfolio. So there are, analogous to what Patrick mentioned in terms of the evolution in the insurance space, there's a lot of hyper specialization in terms of the advisory space to really help you on the sell side optimize the placement of that asset or that business, and on the buy side, find the right asset. I was in a situation where we wanted to acquire artificial intelligence, IP, we wanted to acquire more copyrights, et cetera. And if you can find the right brokers, it is a little bit Byzantine. It's not a fully liquid market to figure out, who has assets to sell and why, because some sellers will be sensitive to who they're selling to. They might want to sell only intellectual property or technology to other operating companies, and not other potential buyers. So there's a bit of alchemy in that, but I think you've hit it at the 100,000 foot level, Louis, and it kind of percolates down from there as a practical matter.
Yeah, I think that the selection of advisors, whether it's a banker or a lawyer, is really important. And it's if you think that you're going to be selling it for 50 million, you're probably not going to find a buyer for more than 25. And you need to be working with advisors that are really comfortable in that segment of the market. It's hairy, it's fast and loose, and there are people that really know what they're doing. And frankly, they're on this call, and it's really a pleasure to work with each of you, and a special shout out for Natasha, who's just an awesome M&A lawyer, who I've really been enjoying working with. To the extent we have a few minutes, I thought we could hit some hypos. Here's the first one about GPL code and Target having distributed some code with open source in it, and how you fix that issue. Anybody want to take that one? Yeah. Well,
I'll take it if there's no, just,
please.
you know, as a practical matter, you want to put, when you're operating a business, you want to put that open source into kind of red light, amber light, green light open source, and how it's used. And GPL tends to be one of the more toxic ones. So this is a bit of a red flag to dig into. I don't want to take too much time on the hypo, but if it's GPL code, it can be, you definitely should be digging further to think about how to mitigate or remediate the problem.
Bam, you just nailed it. You've got to build in some time into your process to recode that line that is using GPL, because you really the financial consequences of leaving it in could be severe. And once it's discovered, Patrick cannot insure it. Next typo: Target's patent license with a buyer competitor seemingly sweeps into buyer's patent portfolio. Adam, I'm sure this has happened to you before in one of your many large acquisitions when you were running Cambridge Silicon Radio. You guys acquired Zoran. You acquired. I'm trying to think of the other public companies you acquired, but there were several.
We did a bunch of acquisitions, yeah, and integrations.
Yeah. Did this ever pop up?
The thing you need to think about is everybody thinks about the landscape static as it is now. You have to think about the ongoing acquisitions and divestitures that could keep happening. So anytime there's a fairly broad brush or sweeping license of a patent portfolio, it should send, again, you should really do a deep dive into that and think about the consequences. Otherwise, you could find your competitor having you know, quite a bit of liberty to simply replicate and copy your products without, in an asymmetrical way, without the reverse necessarily being in place. And that can put you at a competitive disadvantage. So things that either toxify your portfolio as the buyer, so things that impact the upstream portfolio can be particularly problematic. If it's something that the target has lived with, if it's not impacting the buyer's portfolio, you can kind of mentally get there and say, hey, look, you know, that's only that universe of assets that are, it's an impairment on the asset basically. And you just have to think about the level of impairment and basically price it. It can be part of the price negotiations. And
Nailed it. You price it. Thank you, Adam. It's a pleasure to have you on this call, Adam. Thank you. There are a number of other hypos that we had hoped to get through, but given the great Q&A we had throughout, I'm going to skip over them and hit the last and most timely one. Here we are in the middle of COVID, and we're all working remotely, perhaps the target and the buyer are working remotely, and we come across a distressed asset. And the target is challenged in making payments as they come due. In other words, is this a valid going concern? And it's relying on a lot of inbound licenses, and maybe it's delivered some outbound licenses. Adam, Natasha, Patrick, you know, what are the things that, you know, you're thinking about to kind of address these risks, both from a structuring perspective, a diligence perspective, and from an insurance perspective?
So I would start to say, are there any assets that you actually want to acquire from this distressed company? And if so, can they be cleanly taken away or purchased from the company? Obviously, you want to make sure there's no liens or encumbrances on whatever you're trying to buy. Otherwise, it's useless. If you're looking at buying shares, though, you'd have to think about, well, is this a viable company going forward? If they're having difficulty during COVID, maybe there's some insight in terms of whether the company would be viable going forward. So that might be a red flag, just to say maybe it's just an opportunity to walk away. But I would say if there are assets that could be easily kind of purchased without any type of liens or issues with them, I would probably think go for an asset sale. Or if you want to do stock, get a huge reduction in terms of stock, but be wary of what liabilities you're taking on.
What about taking a license from this seller, Adam? You know, you don't really have time to do the diligence that you want because the asset will be gone away by the time you finished a black duck scan and cleaned up whatever you found. To move quickly, would you ever just take a license for this IP, and whether exclusive or non-exclusive, to move quickly?
If it's a distressed situation, you have to be careful that the license isn't going to be voided in a bankruptcy proceeding.
Yeah.
That's your big concern. And so, absent that, if there's not a solvency issue, you can do lots of things by means of a license. You typically don't have the right to enforce the intellectual property rights, but you can do deals. In fact, I did a divisional sale by means of a license, a large operating division, and got the buyer comfortable with that. But the big issue is, you mentioned the distressed asset. You don't want the license to be voided, because then you basically got nothing. And if you embedded it in products, you can have to unwind it. Might be harder than not doing the deal at all.
Yeah, from an insurance perspective, unfortunately, right now, we want to insure the unknown, and this is a pretty known issue. So, as part of the underwriting process now, there are going to be questions about impact on COVID, largely with human resources and personnel issues, and so forth. But I mean, you know, you also look, are there problems? Are they purely related to COVID? And what happens post-COVID? Is there a path forward? And those are some of the things to think about.
I want to thank this great panel for all of their contributions. So grateful to have you all. There's some wrap-up thoughts here. We will share everybody's emails and contact information and a copy of these slides later today or tomorrow. And you know, I encourage each of the folks who are still left in the audience to feel free to reach out to folks directly. I work with each of these folks, and